All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Whitney W. Berger, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to a session of oral argument at the 5th District Court of Appeal. We are pleased to be sitting as the panel for the cases on the calendar today. The marshal introduced me to everyone, but let me introduce to you the panel. To my left, your right, is Judge Eisnagel, and to my right, your left, is Judge Edwards. We have a number of cases on the calendar today. We're going to take a coffee break after the third case and would invite any of the lawyers who wish to stay and join us in the Lawyers Lounge for coffee. And we'll do that after the third case. We have, it looks like, 2 criminal cases and 3 civil cases. The criminal cases, each side will have 15 minutes to argue their case, and the civil cases, each side will have 20 minutes, and the appellant will be able to divide that time between an opening argument and rebuttal. And everyone will do me a favor, please, of checking your cell phones and making sure they're either off or on silent or on vibrate, some way that if they start to ring, that we don't hear it. And we will begin with our first case on the calendar, which is Travis Jermaine Ash versus the State of Florida. How much time would you like for rebuttal?
3 minutes, Your Honor.
3 minutes. Let me set the clock. All right. Well, the green light is while you're in your time. The yellow light will come on when you're in your rebuttal time, and the red light will come on at the close. All right. Whenever you're ready.
May it please the court, counsel. My name is Anthony Candela, and I represent Travis Ash. I want to apologize. With the change in the weather, I've got a little bit of a hoarse throat, so I will do my best to speak clearly and try to move through the issues as best I can and answer all your questions. Mr. Ash was originally charged, and that's part of the situation that becomes an issue in this case, with an undercover narcotics transaction that occurred at a park. The transaction was captured on video with audio. There was a confidential source who was working off some charges.
It's my understanding that the issues are really twofold. First, that the wrong statute number was listed in the information.
Correct.
Charging, I think it was sale within 1,000 feet of a public university is how what the statute number read, but the body of the information and what he was actually charged with was sale within 1,000 feet of a public park. That's the first issue, and the second issue deals with wanting to go back and question the jurors.
Yes, Your Honor, and both of those issues were not raised until much later in the case. The trial proceeded through. Mr. Ash was convicted, and then the Office of the Public Defender, shortly after the trial, declared a conflict. We don't know what the nature of the conflict was. Regional conflict was appointed. They declared a conflict shortly thereafter, and then there was an appointment of counsel, and then another attorney, a private attorney, not part of the registry, entered an appearance for the sentencing and immediately raised both of these issues with a couple other issues, but these 2 issues were raised.
Well, how was your client prejudiced by the wrong statute number being listed in the information?
The problem is that it becomes confusing. So,
what's confusing about it? I mean, he was charged with sale within 1,000 feet of a school. Within a public park. All the evidence introduced at trial had to do with him selling within 1,000 feet of a public park. The name of the park was named in the information. So why isn't this just simply a Scrivener's error?
And that's one way of looking at it, right? The other way of looking at it is that what the state did was they conflated the 2 parts of the statute. Yes, they are both what the state did present at the at the trial made out, I believe makes out, and candor to the court, makes out the elements of dealing within 1,000 feet of a park. The problem is that when it was presented to the trial court and it was objected to at sentencing, which I believe it can still be raised there, because I don't think, unlike in...
Well, don't these technical defects and informations have to be raised before a defendant enters a plea? That means before or at arraignment?
They should be raised either at arraignment or in a motion to dismiss per the way we've done this for years. So you're not going to get an argument from me there. But unlike in a civil matter where I can conform my pleadings to the evidence that's been presented at trial, I don't think there's a mechanism like that in criminal court. Plus, we have the Constitution at play. So if the information is...
Again, going back to Judge Berger's question, what was the prejudice to your client? I mean, the client knew, the lawyer knew, they were talking about the park, Seminole Woods Park specifically is named in the information, and they're talking about subsection D instead of subsection C. I mean, the client knew what he was being accused of. The lawyer knew how to prepare, what the factual issues were. I mean, the police officer testified about the distance to the park from the place of the sale and so on and so forth. I mean, where was the surprise? Where was the unfairness?
There wasn't any. And to be straight, there wasn't any other than this is a technical defect that was raised. Why it wasn't raised before, to answer Judge Berger, I have no idea. Maybe no one read the information until they got to sentencing. I have no idea. And there's nothing in the record to suggest why. But when you begin to read it, part of the issue was the sentencing. He was convicted of a first-degree felony, and the object would have been to reduce it down to a second-degree felony because of the technical defect. I don't know if that carries as much water as it should, but it was raised. So I'm re-raising it again for the court because when you read the statute, it does look like they took the state attorney, whoever put together the information, stuck the part about the schools, the universities, and the part about the playgrounds and parks, and just sandwiched them together in the information, which makes it confusing when you're reading it. If you were to simply strike the superfluous information, and keep in mind there was
Counsel,
no motion.
if there was no actual prejudice to your client, how do we reverse on this ground?
That's a good question, Your Honor. It's not the best issue. In all fairness, it's not the best issue of the two issues.
I mean, is it you're not arguing that trial counsel was misled and prepared the wrong case or anything like that?
No, I'm not arguing that. What I'm arguing is that looking at the information in general, it becomes confusing. And anybody looking at it from outside would say, what are you charging? Are you charging the park or are you charging the playground? You went to trial on the playground. And this isn't like aggravated battery, which could happen with a deadly weapon or great bodily harm.
Is the information so fundamentally defective that it cannot support a judgment of conviction in this case?
No, Your Honor.
Okay.
I'll move on to the second issue.
Okay.
The second issue I think is a little bit more interesting and a little bit more unsettling, quite frankly.
What's the reason for the 6-month wait? The rule says 10 days.
Rule says 10 days or unless good cause is shown.
And what was the good cause?
Well, the good cause was that, a couple of different things. First off, there's nothing in the record that suggests if the public defender had any conversations with Mr. Ash after the verdict before they withdrew. So we have nothing here to suggest that Mr. Ash didn't tell Assistant Public Defender, hey, listen, what was with that question? Can we find out a little bit more about what happened?
Well, didn't the Assistant Public Defender file a motion for new trial within 10 days?
They did, but the motion for new trial was a boilerplate that was, I believe, based on what I was looking at, factually and legally insufficient. It literally just basically complained about some of the facts that were presented at the trial, which a motion for new trial, that's not what you use it for.
How long between the time new counsel was appointed to the time that the motion for the interview was?
It was quite a distance.
Okay, then why not at least 10 days within that time frame?
If I understand your question,
If you're saying that the public defender filed a boilerplate motion, for new trial. And so they certainly filed that within 10 days, so it seems conceivable that the public defender that represented him could have filed the motion for jury interview at that time as well. But given, and we're talking about having good cause for the delay, so new counsel is appointed, why wouldn't we require at least have the motion filed within 10 days of the new counsel being appointed, if we were going to allow an extension of any sort at all?
Well, that's where I was going with this.
Okay.
The assistant public defender, there's no evidence to suggest that there's any conversations between the assistant public defender and Mr. Ash after the verdict. I doubt that Mr. Ash had any input on that motion for new trial. A short period of time goes by, and then at the end of the year, the public defender's office moves to withdraw, alleging some sort of conflict. Regional conflict is appointed, and within a month or a couple of weeks, they indicate a conflict. I don't know if they even had any conversations with, and there's nothing in the record, there's no evidence to suggest that there was any conversations with Mr. Ash.
How long between the time of the conviction and the public defender withdrawing?
Memory serves me, 3 months.
Okay, so, but nothing filed within that 3-month time
Nothing
frame.
filed within that 3 months. And then Attorney Sword was appointed, and I believe that she was only on the case for a short period of time.
Okay.
And then Mr. Davis entered an appearance and handled the sentencing, and within a short period of time of him getting on, he filed a couple of different motions. Motion to strike some evidence that he had been provided for sentencing, the motion to interview the jurors, and a objection at the sentencing regarding the information that we just went through.
Okay, and how much time between when he was appointed and the filing of the motion for the juror interview?
I think he entered an appearance in only a few days, is my understanding of the record. It wasn't a long period of time. To give you the exact number, I'd have to go back through the
Okay.
record, in all fairness. But it was a short amount of time. He raises it, and the trial judge then reviewed it and filed a lengthy order on it, but dismissing it as untimely. Now, there is nothing, it's one of these things where there's not a lot of case law on whether that 10 days is a flat jurisdictional rule, like a motion for new trial, or the ability to file an appeal. But as this court's well aware, the ability to file appeal, we have believed appeals all the time because clients allege that they have told their attorneys and their attorneys didn't do anything about it. I don't know if this falls under that category or it falls under for instance, the 60-day to modify.
If we were to look at the actual merits, I mean, you've got some procedural problems to get past, but if you look at the actual merits of it, what you had is a juror who supposedly wanted to vote guilty but was afraid because there may be retaliation. This was not a juror who reportedly wanted to vote not guilty. You've got a juror who says, I want to vote I'm going to vote guilty, but I'm afraid to. And when the judge, all the counsel and the judge agree, send them back in there and just tell them to keep working at it and don't worry about it. And 9 minutes, I think it was, or less than 9 minutes later, guilty, the jury's polled, everybody on the panel, yes, it's my verdict.
Correct, and that's exactly what occurred. But the question itself gives us like a keyhole look into what the jury was thinking, and they're considering things that were clearly not presented in the trial. And the jury instructions clearly tell them you're to look at the evidence presented in court. You're not to make assumptions about Mr. Ash, who's a 6'3" black man dealing drugs, that he's somehow going to retaliate against you. So obviously this juror is considering things by that statement. Now we have no other evidence, we have no other information to ferret out what it is.
So why wouldn't this be an issue that's in errors in the verdict, as opposed to, some legal challenge to the verdict itself? Because those types of issues aren't subject to attack.
Well, I think if the jurors are not following the instructions of the court, that undermines the confidence of the verdict. And if jurors start considering things that have nothing to do with the evidence, because they're supposed to say, the Allen instruction kind of lays it out what a jury can do. You got two things you can do. You can either agree about the facts, you can agree on a verdict, or you can disagree about the facts. But you can't start looking at other factors that have nothing to do with the evidence that was presented in court. The evidence that was presented in court was on video and audio, this man sells cocaine to an undercover CI who's working off charges. It's pretty rough, but there was nothing about that he retaliated against witnesses or that he would know who the jurors were.
Counsel, didn't your motion need to allege an overt prejudicial act or some sort of external influence?
Yes, and that's what I'm going to, Your Honor.
And how did your motion allege an overt prejudicial act or external influence?
The motion was inartfully drafted by the trial counsel in that issue. I don't know, by putting out that question, though, I think it suggests that the juror is looking at things outside the record, which makes that overt prejudicial, because we can't have things outside the evidence that's presented in court. That's why we're told now that jurors are not to go Google things. Jurors are not to go home and ask their spouses or...
Well, couldn't it have just as easily been an irrational fear of one individual juror?
It could have been, but why not bring that juror in? We do this in jury selection. We have a weird answer. We're now selecting the jury. They'll
I
bring
just
it.
want to let you know you're into your rebuttal time. You only have a minute left, so you can finish your answer. Or you
Then,
can
well, I'll finish my. We bring jurors back in and we question them. It takes 5 minutes and we clear up what may be a cause challenge or a peremptory right then and there. They didn't do that. Had you brought the juror and said, hey, why do you think you're going to be retaliated against? Might have been able to clear this up a little sooner than leave it with this amorphous open answer. And I will reserve the 38 seconds.
May it please the court, my name is Charlene Matthews on behalf of the state of Florida. I would also just like to point out one thing on one other argument on the first issue. The sale of cocaine in a park versus an educational institution, they're both first-degree felonies. So there's just no logical reason why the defendant would be allowed to be reduced, or to be allowed to have the charge reduced down to a second-degree felony and sentenced to a second-degree felony, because neither of those charges are second-degree felonies to begin with. They're both first-degree felonies. The trial court did, in point number 2, the trial court did find that the motion was untimely. It was a motion to interview jurors was untimely. It was 6 months, just about 6 months after the jury verdict. The trial court, though, then went ahead and addressed the merits, and so found that there was no overt intimidation, that the jury interview would be proper if there was some sort of allegation or evidence that there were either overt prejudicial acts or overt intimidation, or that the juror was considering evidence outside of the record, and we just don't have any of that here. It looks like that we have the subjective impression of one juror that inheres in the verdict, and a jury interview under these circumstances was properly denied by the trial court. And if the panel has no questions, we'd ask.
Would
Yes,
you
sir.
agree that the judgment was entered citing the incorrect subsection again?
The information?
No, the judgment sentence, I thought that had an issue as well with it.
There may be a scrivener's error.
Oh, if there is a scrivener's error in the
I think it carried
judgment
over
sentence.
all the way to the judgment and sentence, didn't it?
I see. And I would certainly have no objection to this panel correcting that scrivener's error. If there are no questions,
Nothing
All
else.
I'd
right.
ask
Thank
that
you.
you'd, I'd like to just rely on the remaining arguments as set forth in my brief, and ask that you affirm the judgment and sentence in all respects. Thank you.
Thank you. Got about 38 seconds.
38 seconds. Well, the only thing that I would point out is that, yes, the information does allege the college, but it doesn't list what the college is, which would be a necessary element
But there was no college, it was a park.
Correct, but the state just argued that it was properly charged, and to properly charge a school.
Well, I think what she argued was whether it's a college as it's charged as the statute number, or whether it's public park, they're both first-degree felonies, so why are you asking it to be reduced to a second-degree felony?
Just responding, Your Honor.
No, but that would be my question. Why are you asking it to be reduced to a secondary felony?
Because I think that the defect was improper.
Okay.
I'm out of time.
Thank you.